On behalf of myself and Bob Bauer, my supremely talented and collegial co-director of the NYU Law School's Legislative and Regulatory Process Clinic, I want to welcome you to the second year of the Sidley and Austin Forum. The program this year is Modern Executive Power and Sources of Constraint, and it promises to be very interesting and perhaps a bit provocative. This forum would not be possible without the generous support of Sidley Austin, a renowned international law firm. And it gives me great pleasure, therefore, to introduce John Custer, who is a partner in Sidley's New York office. He is co-head of the complex commercial litigation practice and one of the firm's co-chairs of the recruiting committee. Of particular significance to us, John is an active alumnus of the NYU School of Law. John?
Thank you, Sally. Sidley is proud to support the second annual NYU Sidley Austin Forum on Modern Executive Power and Sources of Constraint, which will be an engaging and enlightening discussion on executive power from many different perspectives. Sidley is a firm with a deep tradition of public service and has long been a destination for lawyers who have served throughout the government. Two of our partners, Michael Borden and Kwaku Akua, each will be moderating one of today's panels. Both have served in the U.S. government. Michael worked for almost a decade on Capitol Hill, including as senior counsel of the House Financial Services Committee during the 2008 financial crisis and enactment of the Dodd-Frank Act. And Kwaku clerked for the U.S. Supreme Court for Justice Breyer and was an attorney advisor in the Office of Legal Counsel at the U.S. Department of Justice, providing legal advice to departments and agencies on the executive branch and on a variety of matters, including questions relating to the separation of powers. In addition to Michael and Kwaku, several other partners at Sidley, including Virginia Seitz, Peter Keisler, and Jim Cole, all of whom have served in the highest levels of the executive branch, once again provided their wise counsel and advice for today's forum. We are very grateful for the hard work of both Sally Katzen and Bob Bauer in putting the forum together to address the very important topic of executive power. They have once again done a terrific job. In addition, we are grateful to Dean Morrison for his continued support of and vision for Sidley and the NYU Legislative and Regulatory Process Clinic to combine their efforts to make this forum a reality and a vital part of the dialogue on topics central to understanding how our government and democracy works. We also wish to thank in advance the terrific and distinguished panelists, without whom the forum could not be a success. Sidley also has a wonderful relationship with NYU Law. As Sally mentioned, I'm an alumnus of NYU, and so are nearly 100 lawyers at Sidley firm-wide, including 35 partners. Sidley is proud to partner with NYU on this innovative forum, and we know that our two institutions can make valuable contribution to the dialogue involving American democracy, citizen engagement, and public service. Over Sidley's 150-year history, a fundamental tenet of our firm has been to honor and support the rule of law in this great democracy. This forum is an example of our continuing commitment to do so, and we are proud to be a part of it. Thank you very much.
Thank you, John. Now, we have a very full day today, and for that reason, our introduction of speakers throughout the day will be exceedingly brief. Full biographies will be in your program, which you should have picked up on your way in. If anyone doesn't and wants to so signal, we'll have people who can provide them throughout the day. We are also going to be trying exceedingly hard to start and end our particular panels on time. Two of our speakers have to get to the airport and have to get to train stations, so we want to make sure that this runs on time. Throughout the day, we'll be taking questions for our panelists. If you have a question, we will have a student from NYU, he's waving his hand right now, who has note cards and pencils fill it out, send them to the side, and we'll go through them and coordinate them and give them to the moderators. So at this point, it is my great privilege to introduce our dean, Trevor Morrison, who's been a staunch supporter both of the forum and of our clinic. He's doing double duty today, setting the stage for the day's events and moderating the first panel. Trevor is the dean in the Eric M. and Lori B. Roth Professor of Law at NYU School of Law. He has done remarkable research, writing, and inspiring teaching in the fields of constitutional law, federal courts, and the law of the executive branch, an extremely well-qualified person to get us started today. Trevor? This is tricky.
Thanks. Thanks, Sally. Greetings to all of you. I think we're all looking forward to a great day. I want to echo Sally's thanks to John and his colleagues at Sidley Austin for their terrific partnership for this forum. I'm really grateful for that ongoing support and leadership, and excited by what today has in store. So before we get started with the first panel, which I'll moderate, and we'll call the presenters up in a moment, just a few words about the basic arc of the day. The topic, modern executive power and sources of constraint, could be approached in a number of ways, and I think in the course of today we will approach it in a number of different ways. So the first panel will really try and provide a kind of overview, thinking about how to think about executive power. So that will feature an initial presentation from Michael McConnell, who will give us his thinking, which is part of a current book project, on how to think about the bases in the Constitution of executive power, presidential power in particular. That is, how to think about those powers that might derive directly from the Constitution and not be subject to change by Congress, how to think about powers that, if the president has them, must be derived from legislation in some way, how to think about some that might exist as a default matter for the president but then be defeasible by Congress if it so chose, and how to justify an account along those lines. And I think this will be illuminating both for the particular content of Professor McConnell's ideas, but also just to give us a kind of framework. One could disagree with his basic approach, but still understand that these are the kinds of variables one wants to think about when, as a constitutional matter, we're trying to think about the shape, scope, and structure of executive power. And we'll then hear from Eric Posner and Daphne Renan, and I think we have Gene Healy, the final panelist, here as well. There he is. Hi, Gene. Who will be offering their own thoughts, both in reaction to Michael and then offering their thinking as well. And as we move through that panel, part of the idea will be to set up some ideas that I think we'll come back to in later panels through the course of the day. The next two, on national security and the administrative state, are organized then substantively, if you want, thinking about domains of executive power. National security can be an internal domestic matter, but of course also covers matters of external sovereignty, relating, of course, to foreign affairs, war as well. And then the administrative state, thinking in particular about domestic exercises and arrangements of power, and giving us an opportunity through both of those, I think, to think about the relationship between the executive branch and the legislative branch, and also then the role of the judicial branch in policing this. So these will be, if you want, substantively arranged panels that will give us an opportunity to explore some of the themes I suspect that will come out in the first. And then in the balance of the day, I think of it really as then talking about the president and certain key other players. Advisors, whether they're legal advisors in the form of the last panel, the president and his/her lawyers, or chief staff members, chiefs of staff, also the relationship between the president and the presidency and the press. And each one of these panels could, on the one hand, be thought of as ways of talking about how power is exercised, also perhaps talking about how power is constrained. When talking about the relationship between a president and his or her lawyers, one is, among other things, I think, trying to puzzle through How is law understood within the executive branch in circumstances where the courts are unlikely to be in a position to enforce that law? Does law realistically operate as a constraint in those circumstances? If it does, who does the constraining? Is it the president's own lawyers? Is it the press? Is it Congress? Is it the public in some more diffuse way? If so, how? And beyond law, what other kinds of constraints are there? Are there norms within the executive branch, ways of doing business that have developed over time that, whether or not we call them legal constraints, still do seem to put some actions off the table or beyond contemplating? And if any of that is ever true, are those things durable? What happens when they come under strain? Can they be replaced after they seem to have been jettisoned for one reason or another? And what are the mechanisms of those kinds of constraints? Those are among the topics that we'll be taking up today, again, through this organization of substantively organized panels. And then I tend to think of the last few as relationally organized panels, thinking about the relationship between the president and these key other players. This is about the president and the presidency in part, but the topic of the panel, I think, is well put to talk about executive power. And the other issue that will come up over the course of the day is that executive power is not necessarily just reducible to the person of the president. The modern executive branch is a big, complicated place, and so we'll be talking really about the administrative state and about the relationship between the White House and executive departments and agencies, independent and otherwise as well. So that's a lot to cover. It would take several courses and several semesters to cover it comprehensively, but we'll do it not by speaking quickly, but by covering, I think, just through some salient examples, key elements of the problems presented today. I really look forward to it. So without going on further myself now, let me welcome up, Sally, should I do that? The panelists for the first panel, and we will get started. As they're coming up, I'll just say, just remind you, as I said earlier, Michael McConnell will begin. He's going to offer thoughts for 15 to 20 minutes, laying out the sort of key components of the thesis in his book project, as I mentioned. And then we'll run through the panel here and give each panelist an opportunity to respond to what Michael has offered. And then we'll continue our discussion from there, and there'll be opportunity at the end to hear from you and your questions as well. Michael?
Thank you, Trevor, and thanks for inviting me to this event this morning, and even more so for hosting me at NYU. I've been visiting at NYU Law School this semester, which has been a real pleasure, and I thank you, all you NYUers, for putting up with me for this time. As we meet on this topic this morning, this is, it's hardly an abstract concern. There is, I think, deep worry and consternation and uncertainty around the country these days about the extent of presidential power. And, I have been teaching and talking about this topic for literally decades, and never have I found students so concerned, alumni so concerned, people at cocktail parties so concerned when they find out what I'm working on. It's like this is suddenly, they become animated and want to know more and want to talk about it. And I think that there are three basic reasons why, interrelated reasons why this topic has, struck the country with such force here in 2017. And, the first is pretty obvious, which is that we have a president who has an unusually intense opposition, people who are really more intensely opposed to his exercise of the powers of the office than is typically the case. But that is coming on, and this is the second point, coming after a president who was unusually aggressive in expanding the unilateral powers of the office. He was not the first to do that. President Obama certainly had precedents His immediate predecessor was pretty aggressive as well in a slightly different way, but I think it's difficult. It would be difficult to argue that Obama did not push the envelope, and so you have powers expanded and now in very different hands. And then the third point is that for very complicated reasons that I don't have time to talk about, Rick Pildes here is one of our experts on it, Congress seems to be paralyzed. And it's not just the Republican Congress, it is Congress in general. It was Congress when both houses were in the hands of the Democratic Party. There is a deep problem with the way the legislative branch operates. So George W. Bush certainly was surrounded by lawyers who believed in a very powerful unitary executive and pushed theories of the executive power which were rather dramatic. Domestically, not so much. Primarily, not exclusively, but primarily, President Bush extended the powers of the office in the national security arena. In going to war in 2 different places, he actually did get authorization from Congress. So that was not the place where this manifested itself. It was more in the area of surveillance, interrogation, and other national security matters. President Obama, but I want to comment about this. So as President Bush did this, there was considerable blowback. That is, the bar associations, especially the Bar Association of the City of New York, would pass resolutions criticizing the extension of power. The major newspapers editorialized. The press was alarmed. There was the Academy was resistant, and so we see a process here of the administration pushing, but the forces of the culture and society resisting. And then Barack Obama, as candidate for president, was quite forthright in criticizing this executive unilateralism. When campaigning, he said, and I quote, "The biggest problems that we're facing right now, the biggest problems that we are facing right now have to do with George Bush trying to bring more and more power into the executive branch and not going through Congress at all. And that's what I intend to reverse when I'm President of the United States of America." And yet, when elected, President Obama took a rather different course, especially after his party lost control of first the Senate, or first the House of Representatives and then the Senate. President Obama became famous for using what he called his phone and his pen to make policy without having to go through Congress. Let me just mention a few examples. Some of these may be controversial, but I suspect many of them are not so controversial. So President Obama made recess appointments when the Senate was not in recess. He spent billions of dollars on Obamacare subsidies that Congress had not appropriated. He started an offensive air war in Libya without going to Congress for either a declaration or even an authorization for use of military force. He declined to defend statutes passed by Congress before the United States Supreme Court. He gave a form of lawful status to millions of persons illegally present in the United States after Congress had specifically refused to make precisely that amendment in the law. All of these dramatic changes in the way in which the executive branch had operated in the past. But I think what is most disturbing about this particular set of episodes isn't so much what was done, because I expect presidents to push the envelope. It was the lack of blowback among the various responsible institutions that one usually would expect to defend the constraints in our system. We heard a lot of applause for each of these actions and very little criticism. The bar associations were silent. The academy, for the most part, was silent. The major newspapers, for the most part, were cheerleaders rather than critics. And so the executive branch and the presidential power increases. I am reminded of the English philosopher John Locke's famous statement in the second treatise on government, where he said that good princes are more dangerous to the rights of the people than bad princes. Why? Because people will applaud their use of power, and this will then establish precedents for the future that will not be so happy. Well, at least to the Democrats in the audience, I want to say, you had your good prince, and now we have our precedents. And so, in a way, I think that that means that today is not just a time of concern, but actually should be an opportunity for reflection. Because I think that having gone through a period of aggressive unilateral executive power under a president of one stripe and now having a president of another stripe, maybe it's an opportunity to reflect on a more bipartisan or nonpartisan basis on where exactly we think that the presidency should be. And it has to be bipartisan because it cannot be that presidents of one political party are required to be constrained and presidents of the other political party are not. Whatever one may think of Donald J. Trump, he is just as entitled to exercise the legitimate powers of the presidency as his predecessor was and as his predecessor was before him. So maybe this gives us a chance to talk behind a kind of not quite a veil of ignorance, but at least a veil of what's sauce for the goose is sauce for the gander. So what are the sources of constraint? Essentially, I think that there are three principal legal sources of constraint. Of course, there are political sources of constraint, and I think some of the other panels will be talking about that. But I want to talk about the law. And so the legal constraints begin with the text of the Constitution, especially Articles 1 and 2, the powers of the Congress, the powers of the President, supplemented by judicial interpretations. But here we actually don't have very many judicial interpretations. They are scant, and they are also a bit internally inconsistent. You have cases that proclaim, enormous discretion for the president, and you have cases that seem to go the other way, and it's a very sparse set of issues, and I think for a variety of reasons, separation of powers questions are not primarily in the judicial bailiwick. When there are judicial decisions, of course, that gives us a source of law. And then the third, and perhaps at least more important than the judicial interpretations, is longstanding practice. And this may be what Trevor was referring to as norms, but I think in our system these are a little bit more than just norms, because there's a kind of precedent that is set with actions over time, and then oftentimes when the courts do become involved in separation of powers questions, they reflect upon the history of practice and let the longstanding practice guide the judicial determination, so that even when courts become involved, it's often the non-judicial action over time that has set the rules of the game. That said, I especially would like to warn against too heavy a reliance on longstanding practice because the executive has, because of its famed secrecy, energy, and dispatch, the executive has tremendous first mover advantages, and and I don't really think we want it to be so that just because successive presidents have gotten away with something, using a loaded language, gotten away with something, that necessarily means that a new legal norm has been set. I mean, I give you the, I think, relatively clear example of war, where we've now had 5 or 6 at least, perhaps more, but 5 or 6 at least major conflicts in which the president did not get the authorization of Congress before going to war, and under circumstances where I think that even a relatively generous understanding of presidential discretion to repel sudden attacks and to engage in defensive measures and so forth, a relatively generous, even a generous understanding of presidential discretion falls short of justifying the conflicts. And if you read the opinions of the Office of Legal Counsel on these questions of war, you will now see that each time we have one of these conflicts, that they just add the last one to their series of precedents, and you can just see John Locke nodding and saying, yeah, that's what I told you was going to happen, right? And do we really think that the president now has not just the power, but the constitutional legitimate right to take this country into offensive wars without going to Congress first? At least I do not. I want to spend the rest of the time talking just, though, about the Constitution itself and its text. The part of the problem here is that if you just open the Constitution and read it, Article 2, which is the provision of the Constitution that defines the powers of the president, is, I think, the most disorganized and confusing part of the Constitution. Every year when I teach the basic con law course, the very first day, I have the students do nothing but read the Constitution itself, and we just talk about the Constitution as a document, and it's really evident, that Article 1 is quite lengthy and detailed, and makes a great deal of sense. Article 3 is fairly short, but logical and easily comprehended. It has some technical legal language, but it's not difficult. But Article 2, it's very hard to understand what it's doing. It includes some almost incredibly trivial powers, but it leaves out some things that seem to be very significant. It seems to be a bit of a jumble. Why are some things in Article 2, Section 2, and other things in Article 2, Section 3? What's this? What is the principle of organization? And so I think Article 2 is a very difficult text to understand. I think it helps to know how it was put together. As the delegates gathered in late May of 1787, the person whom we generally regard as the father of the Constitution and the principal architect of the first draft, which was the Virginia Plan, James Madison, did not understand he freely admitted in a letter to Washington just before he took off to Philadelphia that he had not given very much thought to the question of either how the executive would be constituted or what powers it should be clothed with. And so our sort of organizing genius of the Constitution didn't help much here. And then on the first day, it comes, the Virginia Plan provision for the executive comes before the delegates, and it's really, I think, the most dramatic moment in the whole summer. This is June 1st, and it says the executive power is going to be vested in a single person. That's the motion before the House. And young Charles Pinckney, he's not literally the youngest person there. He lied about his age. He's actually the second youngest delegate, but you can almost hear him gasp, and he says, why, that will make him a monarch. That'll make him a king, an elective monarch, the worst kind of monarch. And then the notes say there's a considerable pause ensued. It's the only time all summer that you don't have multiple people standing up and all trying to talk at once. A pause ensues. Why is there this pause? Well, it's because Pinckney is made a very sound point. It's like to vest all of the executive power in a single person means we're going to have an elective monarch, and that doesn't seem consistent with our Republican traditions. But what are we going to do about it? There was no experience as of 1787 of a large-scale republic with a vigorous executive. They didn't know, they had no models to follow, and Madison is useless for a change. Usually he's a source of a great deal of wisdom. He's useless. And to make everything worse, George Washington is sitting right there. He's the presiding officer at the Constitutional Convention, and everyone knows that George Washington is going to be elected the first chief executive of the country. And so when you talk about how are you going to make comments about, oh, well, this could lead to tyranny, or think about how that power could be abused? It's like, are we criticizing, George Washington? It's very awkward, very difficult. Right, and so Benjamin Franklin, among others, Benjamin Franklin says, no, we really have to talk about this. This is very important. But the initial reaction is to strip the executive of most powers and to give him only 3 specific enumerated powers and nothing else. Just the power to carry the laws into effect, to make some appointments, and then to have a qualified veto. If that were all that the president could do, the presidency would be a mere shell, right? And then they don't do they don't even return to the discussion of the powers of the presidency until about halfway through the summer. And then it's really hashed out behind the powers of the presidency are hashed out behind 2 committees where we don't have the records for exactly what they were saying, what they were thinking. And so we can only piece together the powers of the presidency from a careful examination of what they were looking at, what they did, and actually the product of their labors. So in my studies of this, here is my conjecture as to what they were doing. The approach that they took to creating the powers of the executive is that I think that they took their understanding of executive power from the experience with the king, specifically Blackstone. In William Blackstone's commentaries on the laws of England, he talks about the prerogative powers of the king. Every single prerogative power of the king that Blackstone mentions, with one exception, is specifically parceled out in the Constitution. I think that's very interesting. But they did not give it all. They did not give all the executive power to the president. If you think of executive power as meaning the prerogative powers of the king, they gave many extremely important prerogative powers that are exercised by the king under the British system to Congress. In fact, by one count, and there are different ways to count this, but by one count, 13 of the 29 powers that are expressly given to Congress were prerogative powers of the king in Blackstone. Then they give other powers to the president, and specifically enumerating them in Article 2. But many of these are massaged in ways that that diminish them. I mean, often rather technically. So I'll just mention one example of this. So the king was the commander-in-chief of all of the armed forces of Britain, whereas the president is the commander-in-chief only of the Army and the Navy but not of the state militias, which are much larger military forces than there was no Navy, much larger military forces than the standing army, and the militia only when it is called into the active service of the United States, and then only for 3 enumerated purposes. So in fact, there's a big contrast here between the king, who had a monopoly over all military force within the kingdom, and the president, where much of the military force of the United States is actually going to be under the control of the state governments rather than being under the control of the president himself. That's just one example of the way in which the prerogative powers that are given to the president are carefully re-examined and shaped for the purpose of making sure that we had a presidency powerful enough to accomplish its Republican objectives, but not so powerful that the president was going to become a king. So when the dust settles, there turn out to be 3 different kinds of power given to the president. Trevor already stole my thunder on this. Thank you very much, Trevor. But maybe you weren't paying attention to Trevor, so I will repeat the basic organizational scheme here is that certain powers, prerogative powers, are vested in the president. And these are powers that the king had, but in some cases that the king had not recently exercised. So, for example, the veto power, very important in our system, is the veto power. Now, our president doesn't have an absolute veto, which the king had. He can be overridden by supermajorities in both houses of Congress. And the precise mathematics of that went back and forth during the course of the convention. So you might think that that's a diminution of the president's power relative to the king. But in fact, as of 1787, the king had not exercised, the king or the queen had not exercised the veto since Queen Anne, and that was a kind of a dubious case, really since King William. So it had been very close to a century since that the king had not exercised the power. And it had become thought to be, the king had this power, but it would have been extraordinary. It would have been contrary to the norms in which of the 18th century system for the king to exercise that. By making the veto non-absolute, our framers actually made it more usable by the president, right? Because it's precisely its lack of absolute character that enables it to be actually politically usable, right? And so rather than, on the surface it looks like the president's power is reduced, but in fact his power is increased. So in any event, so you have these prerogative powers that are now vested in the president, often recalibrated in important ways. But when they're in the Constitution, that means that they're actually constitutionally entrenched in a way which nothing was ever constitutionally entrenched in the British constitutional system with their unwritten constitution. So with the unwritten Constitution of Britain, there were norms which were well established and binding, but those norms could be changed through a variety of processes. Our constitutional embedded prerogatives can't be changed without a constitutional amendment. That makes them much more potent than the king's prerogatives. And more important even than that, by the time of 1787, it had become understood that the king would exercise his prerogatives only on the advice of his ministers, and his ministers were not his own selection. The ministers would be the people from the majority faction in the parliament. So effectively, the executive branch was under the control not of votes of parliament, but of people from the majority faction in parliament. Well, this is one of the major topics of debate all through the Philadelphia Convention, is whether the president should have a council like this, a privy council like his ministers. And there were some major people at Philadelphia who wanted a system of that sort, but it was seriously considered and voted down, so that we have a president who is expected to exercise the prerogative powers of his office on his own. That is, I mean, maybe he'll take advice. He can seek advice as much as he wants to, but the buck stops here. Nobody can stop him. So in a sense, we have a presidency with fewer powers than the king had, but the powers that he does have are more entrenched, and they are more personalized in the president himself. But then there are two other baskets of powers. In that basket are, of course, the pardon and the veto, and some, and there are two that I think are particularly important and have been in debates over the last 20 years, last two administrations. The commander-in-chief power and the power the duty, really, to take care that the laws be faithfully executed. The commander-in-chief power was at the heart of many of the George W. Bush administration controversies, and if we had been talking on this topic 8 years ago, I would spend more time explaining how the founders, I think, were very careful about the commander-in-chief power, giving many of the aspects of that to Congress. I believe that the notion that the president, using that power, is able to trump congressional statutes having to do with, for example, standards for the interrogation of prisoners, is a misunderstanding of the structure of Article 2. But I'm not going to talk too much about that. The key thing here, though, is that Congress decides how much of a military we're going to have. It has the right to raise armies. So they decide how much of a military we're going to have. The Congress writes the rules for the conduct of the military, and Congress has the authority to decide when we take the military into action. What the president's power is, and it's very important, he's the one who commands, but he isn't the one who decides what kind of army it is or what it's going to be used for. But Congress cannot assign to someone else the authority to command the troops. The take care clause, I think, is rather similar to that. Take care that the laws be faithfully executed. Congress determines what the laws are going to be. But Congress does not determine who is going to supervise the execution of those laws. And this is, I think, a point of departure in our system, where we have come to tolerate an idea that Congress is able to make various agencies so-called independent of the president. And cases like Humphrey's executor in the Supreme Court have blessed this practice, but I think that this is really quite contrary to the actual constitutional scheme. Congress can change the laws as it wants. It has total control over substance, but it does not have total control over personnel. It has the authority to vest the enforcement of the law on various officers who can be made subject to the advice and consent of the Senate, and thus there can be a certain check on the president's ability to run the government simply through his own cronies. But in the end, it is the president who takes care that the laws be faithfully executed, and not somebody else. And I don't think the president can legitimately be taken away from being the chief, the person who's at the top of the supervisory chain. So those are the prerogative powers of the president. Much of the power of the president, though, comes only through delegation from Congress. and this is a very important structural provision decision made by the framers of the Constitution, the power to tax, the power to borrow. That's an important one, by the way, because this is why the debt ceiling crisis hits us, from time to time, is that the president cannot borrow a dime more without Congress's authorization. So if Congress has authorized a total debt of, $10 trillion, and you come to that ceiling, the president is not constitutionally authorized to do any more. He cannot spend money without congressional authorization. This is why I think the decision of the last administration to go ahead and spend $7 billion a year to make Obamacare work, make its subsidies work, I think, as the district court held in that in the case challenging that, was quite in excess of presidential authority. The president cannot make offenses to be punished. He cannot go to war. There are a number of things where the president simply cannot act without advance authorization of Congress. And I think we have gotten to a point where we are too quick to see implied authorizations, so that presidents often seem to think that they can do things so long as Congress has not said no, whereas in many of these areas having to do with delegated powers, the constitutional rule is the opposite. The president can't do anything unless the Congress has said yes. It's not the other way around. And then there's this third category of residual powers, not enumerated. The foreign affairs powers are the most salient, most easiest example of this, but they're not the only ones, where the president is able to take action on his own authority, but Congress, exercising its own enumerated powers, is able to override the president's actions, regulate the president's actions, reverse the president's actions, and so forth. A non-foreign affairs example of this has to do with the budget area. And again, this is my opinion. I'm not telling you something which is sort of established consensual fact, but in my opinion, when we do reach these debt ceiling crises and there's not enough cash in the till to pay off everything, I believe that the president does. I think my opinion is that it's well established that the president has the right not to spend money that has been appropriated by Congress. Although he has no power to spend when it hasn't been, I think he has the power not to spend, and thus that the president can prioritize spending, and these crises need not be quite as bad a crisis as they're made out to be. That the president can make sure that the money goes. We pay off our debtors, we pay off Social Security, we deal with the most urgent needs, and not. But I do believe Congress has and probably should exercise its power to create its own priorities in these circumstances, and I would wish that Congress would be more forthcoming about it, so that we don't have these sort of desperate debt ceiling crises every 6 months or so. It ought to be a more orderly process than that. So these are powers where the president doesn't have to have advance authority from Congress, but Congress is ultimately has the last word. So I think in some respects the presidency that we have conforms to this model, but in many respects it doesn't. And I think that as we move forward with this new and rather unusual president that we have, that it may be a good opportunity for us to really be able to think more realistically and on a more nonpartisan basis about how the powers of the presidency are constrained by the Constitution. Thank you.
Thanks, Michael. Okay, so we're going to give each of the three members of the panel to offer their opportunity to offer their reactions to what they've just heard, but just to, in a sense, underscore the distinctiveness of this division of presidential power that Michael has presented us with. The students in the room who've relatively recently taken constitutional law, no matter who it was taught by, almost certainly when taking up issues of executive power will have spent some time with the Youngstown case and Justice Jackson's concurring opinion. Whether one admires or doesn't admire that opinion, it's hard to deny, I think, that it's by far the most influential judicial opinion giving a framework for how to think about this. And it can be worth contrasting Justice Jackson's three-tiered organization of presidential power with the presentation just offered here, which also has three categories, but don't mistake them for being the same approach. They're quite different, right? And they're really, I think, the important part of departure, I mean this just not as my own evaluation, but sort of conceptually, is how to think about the most uncertain cases, the cases where Congress has not said something clearly. And just as Michael said, his approach gives us a way of sort of saying, well, it depends what kind of power it is. With a certain set of powers, if Congress has done nothing, then this is a residual power belonging to the president. In other circumstances, if Congress has done nothing, then there is no authorization for the president to act. And that has a way of sort of sorting through the cases of congressional silence and deciding on the legitimacy of the presidential action. That's not the way Justice Jackson suggested approaching this. He would have tried to figure out, well, what kind of signal has Congress really sent, explicitly or implicitly, and would have put a lot of weight in even finding some implicit signal from one way or another from Congress. And then if there was no signal whatsoever, the most we got from Justice Jackson is suggestion that contemporary imponderables, whatever that means, would resolve the case. I tell my students every year that I barely resist the temptation at exam time to just make the entire exam one question: what are contemporary imponderables? But I haven't done that yet to my students. Maybe this panel can answer that or offer their other thoughts. So that's just one way of contrasting this dominant Youngstown framework with what we've heard in Michael's presentation just now. I'll start with Daphne to take up any part of what you've heard.
Sure.
We'll go from
So
there.
immensely valuable and understanding the history and the kinds of questions and challenges that the framers were contemplating and the history that they were building on in structuring our Constitution is an immense contribution. I thought maybe in responding to Professor McConnell's project and also in setting the stage for our discussion today, to maybe broaden a bit how we think about normative constraints on the presidency. So as Professor McConnell says, our constitutional text is quite sparse, it's ambiguous, and I think as important, it's fundamentally disconnected from the historical and institutional development of the presidency since the founding. The nature of the presidency today, the duties and the authorities of the office of the presidency have changed dramatically in response to historical, institutional, and political developments. So maybe just as you identified practice but cautioned against an overemphasis on that, I would caution against an overemphasis on the original understanding of these terms and submit to you that I quite agree that judicial precedent turns out to be quite sparse and abstract, vague, and inconsistent in setting out the duties of the presidency. And I think what we have as the real working normative infrastructure for the office of the presidency comes from norms, from these unwritten rules of political behavior that do change over time, but also become entrenched through different processes and as a result of various conditions that we might talk about on our panel. And if we think about the sorts of functions that Professor McConnell has drawn our attention to and the sorts of functions that we think about a written constitution as serving, so allocating certain types of authorities to different types of branches, insulating certain types of actions from certain types of actors, structuring discretion to make it less arbitrary, protecting against self-dealing or the corruption of power, the kinds of functions that we think about a written constitution as performing, what we see is that in the day in, day out practice of presidential governance, it's really these unwritten rules that serve these functions and that give us the thick normative tapestry of the office of the presidency. So sometimes these unwritten rules fill gaps in the constitutional structure, in the constitutional text, and sometimes I think they even push against some of the original understandings of what that constitutional text was designed to do. And understanding them as part of the normative infrastructure that does and should govern our presidency shifts a bit how we understand the relationship between text, original understanding, and ongoing development through norms and norm-based practice. So ultimately, I think in a discussion like today, when we're thinking about the constraints on modern executive power, putting those unwritten rules on the table and seeing how they have interacted with text and in some ways shifted our understandings of the presidency away from these founding debates is extremely important.
Yeah, Eric. Yeah.
Okay, so I pretty much disagree with everything that Michael said. So first, let's start with history. Obama, to use Michael's words, pushed the envelope on presidential powers. So did George Bush. So did Bill Clinton. So did Ronald Reagan. So did Richard Nixon, Lyndon Johnson, Truman, definitely, Franklin Roosevelt, obviously, Woodrow Wilson, Teddy Roosevelt. Now, most of these presidents are actually considered great presidents. Some disagreement about Nixon, but if you actually look at the presidents who are rated the best by historians of both parties, and you'll see that they're all powerful presidents. They're all presidents who've pushed the envelope. They're the ones who violated the rules of the Constitution to the extent that we can even figure out what they were as set out by the founders. And I think, one has to wonder why. Why does it turn out that the most powerful presidents, the most aggressive presidents, also turn out to be the most revered presidents, at least with the benefit of historical hindsight? And the answer is that if you go back to the 19th century, the national government was terrible. It had a weak president, for the most part. You put aside Lincoln, who obviously was operating under special circumstances. You put aside Jackson and Polk, maybe. The presidents from the Virginia dynasty to the end of the 19th century were weak. Congress was the major organ of government at the national level. And Congress worked as badly then as it does now. And so if you look at history, what seems to be the most plausible explanation for what's happened is that in response to the perceived inadequacies of Congress and the original structure of the government, there is a shift in power to the presidency or to the executive branch. Interestingly, Congress acquiesced in this along the way, not always, but most of the powers of the president were actually created by statute, most of the powers of the president today. How could the founders have gotten things so wrong? Well, some things I do agree with that Michael said. They had no idea what they were doing. They didn't really know what the presidency was going to look like. They didn't have any good models. They had models of legislatures, they had models of courts, but they didn't want to create the British king. They didn't want to create colonial governors. They had, the governors of the states during the Articles of Confederation period were weak. They weren't terribly happy about them. They didn't really know what they were doing. They very much hoped that George Washington would figure things out. The one thing they had going for them is that everybody agreed that George Washington was a good guy, and he would try to be a good president. And, we can wait and see. And George Washington was an aggressive president who pushed the envelope, established many of the precedents that are still with us till today. And other presidents, like Jefferson as well, pushed the envelope. They were able to do so because they were founders. They had the prestige as revolutionaries. But basically, Jackson destroyed the presidency, and after that, it was this weak institution. I don't think the sort of antiquarian speculations about what the founders were trying to accomplish, whether they were reacting to the prerogatives or something else, the British King's prerogatives or something else, is helpful today. I think it's not helpful at all, in fact. I think it's an exercise of nostalgia to go back and look in the 18th century and hope to find guidance at a time when not only was there no internet, there was basically, no type of communication beyond, sending a letter to somebody. There was no steam engine. There was, the country was mainly agrarian, very small, basically in many places a slaveholding aristocracy. The founders wanted to create an elite governed system of a sort which is now considered unacceptable, at least in the public view. And that's why they set up a structure in which ordinary people would not be able to elect the president or senators. In fact, in many states, most ordinary people, putting aside, women, African Americans, all the rest, they couldn't vote. But most people could. Well, depending on the state, many people couldn't vote because there were franchise restrictions. Most of the founders were fine with that. They didn't think ordinary people should have too much political power. They didn't trust ordinary people. The world's changed so dramatically in terms of technology, the role of the United States, and general attitudes about how the government should work, that while we should revere the founders, they did a good job. They got us started. We shouldn't go back and look to them for wisdom. Well, what does that mean? I mean, that means that we have to decide, here and now, what we want the presidency to look like. And this might sound dizzying in a way. If we can't, go back and rely on the wisdom of the founders, what do? And the answer is we rely on ourselves. And we go back and we can evaluate what President Obama did and President Bush did and Roosevelt and all the rest and make a judgment, a bipartisan judgment, one hopes, about which powers they actually needed, that were actually necessary in order to govern the country, and which powers were too vulnerable to abuse. And we have object lessons in both directions. We see, and again, with the benefit of hindsight, if you maybe move beyond Obama and to Bush, I think at some point, as you go back earlier into the 20th century, there'll be some convergence, even among people who belong to different parties, that Nixon, for example, should not have spied on his opposition, the Democratic opposition, and there should be both norms and laws in place to prevent the president from doing that. But on the other hand, that in a modern world, you need a large bureaucracy in the government to regulate, and that we probably want that bureaucracy to be under the authority of the president. So I think there's no avoiding that type of normative and political debate, and that we should avoid trying to go back to the founders to answer these questions for us.
Gene.
I wouldn't put too much stock in the judgment of history and the fact that if you look at these perennial historical rankings of presidents, that you tend to see activist presidents towards the top. I'd suggest that in some ways, the presidential rankings and the judgment of history is demented, frankly. Woodrow Wilson still routinely shows up as a top 10 president. It's a president who took us into an unnecessary war and ran one of the most severe crackdowns on civil liberties in American history. His successor, Pleasant Warren Harding, who pardoned some of Wilson's political prisoners and basically presided over peace, prosperity, and an era of normalcy, is routinely, close to the bottom. So I think there's a perverse preference for action and activism, for maybe even a desire for entertainment among the political scientists and historians who fill out these presidential scorecards. I mean, there's a couple of studies, one by a pair of economists a few years ago that ranks the number of U.S. combat that relates the number of U.S. combat deaths under a given president with their historical ranking, and finds out that there's a positive relationship. So that's my hobby horse on that issue. I do think it is worth looking, as Professor Posner does in his book, Executive Unbound, at sources of constraint on the executive that are non-legal. And particularly in the area of presidential power that seems to be the most unmoored from the Constitution, that is war powers. Whatever the sources of constraint are on presidential action in the war powers arena, they don't seem to be constitutional and they don't seem to be statutory. In Libya, you have President Obama launching a war against a country that his own Secretary of Defense admitted on national television was not a vital interest for the United States, blowing past the limitations of the War Powers Resolution when it became clear that our allies could not carry on the air war without us. And you had a fairly radical expansion of the 2001 authorization for the use of military force to cover a group ISIS that is not only not connected to the original target of that resolution, but has been excommunicated and denounced and is openly at war with Al-Qaeda, the target of that resolution. So what the constraints are in the war powers arena, I don't know if you'd call them norm-based, but I think they're largely political. Even though you have a quasi-precedent from President Truman launching a major ground war, that's the kind of thing you don't tend to see in modern war powers practice because it would be deeply unpopular, as indeed the Korean War was. And this is why I think you see modern war powers practice. The large expeditions involving a lot of ground troops tend to get, as Iraq did and Afghanistan did, tend to get congressional authorization. Everything else tends to be what Jack Goldsmith calls light footprint warfare, where it's partially in the dark and where there are low casualties. But in all of this, it doesn't seem that statutory text or the original understanding of the Constitution is doing much work here.
So one way we could proceed from this is to think that there might be at least three accounts of how to think about the legitimacy of any particular exercise of presidential power, how to think about that legitimacy. Three sort of on offer in what we've heard so far. One is that one should look to the text and original understanding of the Constitution as revealed perhaps by practice under that text, so long at least as the practice isn't visibly inconsistent with the original understanding of the text insofar as we could know it. Let's associate that roughly with an approach of the sort that Michael McConnell has laid out, though of course one could have a different account of the original understanding and then there would be a different set of answers. Another, I think Daphne's referred to this, and Jean and Eric in certain ways too, might be capturing some of this, which is to look at just how the power has been exercised over time, and insofar as presidents have been allowed to exercise powers that way, that is, other institutions haven't intervened in some way to stop them, that's built up a kind of understanding over time, a practice-based understanding over time of what the metes and bounds of presidential power are. They just are those metes and bounds because that's the scope within which presidents have acted. That's related, but not the same, I think, as the account that Eric gave, which is, I think, a more kind of straight-up, pragmatic appraisal of the wisdom of particular exercises of power, where we're thinking, I guess, about, well, what sorts of powers might be most likely to be abused or exercised in some way that's not good with reference to overall social welfare or something like that, national interest. So for either of the second two approaches, someone who's an adherent to the original understanding is going to say, what's the stopping point, right? It's going to be the sort of precedent question, the question of, like, might a good prince lay down some precedents that then can be used in untoward ways by the bad prince, et cetera. This is the Justice Jackson's concern about a precedent being like a loaded gun being left lying around for someone else to pick up and do something bad with. And so, Eric, I in particular wonder what you think about how to answer that question with reference to the approach that you were describing. So if in moment one we saw presidents exercising a certain kind of power and it seemed to be in the national interest, would that be enough to establish the legitimacy of the exercise of that power in a going forward way so that a president could invoke that precedent in time two, even though that president might be more inclined to be abusive with respect to that power? Or on your approach, is there some way of deciding between those two and reaching different conclusions on legitimacy?
I think, yeah, I would combine the second and third approaches. And to answer your question specifically, I would say that if a president, let's say, to make it as clear as possible, usually they don't propose, but I'm going to do something, I'm going to do X, Y, Z, and then the rest of us have to respond to it. And so there are two ways to evaluate what the president wants to do. You can evaluate it first on basic normative grounds. Does this advance the public interest? So we could use President Obama's immigration initiatives, for example. Is it a good thing, what he wants to do? And we could agree or disagree about that. And then the second issue is, if to the extent you think President Obama is doing something new, is it a good thing for presidents in general to have that power? And people had this debate at the time. The debate was quite full-throated and complete, and people said, well, you know, if Obama can do this, couldn't a future Republican president refuse to enforce the corporate tax? You know, and people had that debate.
Right.
That's exactly the debate they should have had.
Okay.
And then but you have to make both an institutional and a normative judgment at the same time. I think that's in fact what we do. I think that's what other countries like Britain does when they're making they make constitutional judgments as well as normative judgments. And that's why in a place like Britain, the Constitution can evolve in a relatively explicit way, whereas in this country, because of the lingering, I guess, prestige of the founders and the continuing influence of originalism, a lot of it is more hidden. That's why, as Michael mentions, presidents often say, well, I have this implicit power or something like that. But precedent is powerful. So if Trump wants to not enforce the law, he can say, well, when Obama did that, you guys approved, and I think that's a reasonable argument for him to make. But we just have to evaluate it. Is it right? Is it the same type of power? Should we have approved of what Obama did? Maybe we were wrong, and that's the kind of debate that has to take place.
So one big question embedded in there is this. If accepting the legitimacy of the prior act, if that happens, then is it somehow out of bounds to change the answer here? In other words, Michael would say, well, if it was illegitimate in the past, then just repeating the mistake is just repeating a mistake. And I think you're saying,
I don't
well, if
think
you
it's
accept
right. It's not conclusive. You know,
Okay.
you can say, I was wrong last time. The problem is if your views always track, the partisan preference, then you look like an idiot. I mean, there's no doubt about that, right? So it's good occasionally to say that the president that you like shouldn't do something, right? Because you're afraid that you've got your loaded weapon. So in the future, when the president you don't like tries to do something you don't like, you'll be able to say, well, I'm being consistent here. But in the real world, people change their minds. They update their views as they learn things. It's quite possible to, for example, have supported Franklin Roosevelt, thinking, look, he's addressing the Depression and the war, and this is fantastic. And then later on, to have second thoughts about it and say, oh well, maybe he went too far in certain respects. And I think that's part of the problem. People legitimately can change their minds. But if they do it in a too casual and partisan way, they lose their credibility.
Maybe we could just give you, sir, why don't you add something? And then I think let's put a concrete example or additional one or two on the table just to see how these different approaches would come to different answers. But Daphne, you want to say something first?
Well, two things. One is that I think there's two separate questions. And one is, how do we identify what the presidency actually is today? What does it look like sociologically? And the second is, how do we assess it or decide normatively what's legitimate or desirable? And I think for both of those sets of questions, we can't do that without looking at this norm-based practice. And if we look at just the text and the original understanding, we're missing a dramatic evolution in the nature of the presidency today. And that statutes don't give us the full picture of either. So even before we begin to assess what is normatively desirable or legitimate, just to see what the presidency looks like, what the actual operative constraints on the office are today, we have to have tools to get past the formal legal instruments that we often talk about as lawyers. And the second is just, we've been talking about practice from the perspective of something that's derived entirely through endogenous pressures internal to the executive branch. And so we worry about the first mover advantage of the president structuring practice. But practice often develops as well in response to external pressures in the legal culture about what expectations of licit and illicit conduct look like, external pressures through professional communities that develop their own norms of what counts as legitimate intelligence or law enforcement or scientific analysis of data, and those shape the norms of the presidency as well. So I don't think it's fully accurate, and it can be misleading in important ways to think about practice as something that comes entirely from internal forces as opposed to this dynamic with external law, culture, professional expectations, and politics, obviously.
That's a very important point, and it surely will be something we'll come back to over the course of the day, which is, although it's important to isolate out and to try and understand legal constraints as such, if we're trying to understand the shape and influences on the exercise of executive power, that's not just a legal question. And actually then even saying what the presidency is, as well as what kind of constraints it's subject to, goes beyond a discussion on any account of law, is going to go beyond a discussion of things that hold themselves out to be or understood to be purely legal constraints, as you say. So in application, Michael, I'll give you a chance to answer the question I'm posing now first and to respond as you'd like to what's been said. Let's think about a couple of examples. Maybe we could start with one from the foreign affairs side of things, and this is the Zivotofsky case as it went to the Supreme Court, with a clash between the executive branch and the legislative branch. Here we have the executive branch having continued, this was the case came to the court during the Obama administration, continuing a pretty unbroken practice for decades of the executive branch studiously not taking a position on what country Jerusalem is located in. And avoiding that in part through practices with respect to passports. So if a U.S. citizen, or if a child of U.S. citizens was born in Jerusalem, whereas typically a passport, if it were obtained, would list as place of birth the country, the practice would be simply to say Jerusalem and not to specify country. But Congress passed a statute giving the option to the parents of a child in that circumstance to insist that Israel be identified as the place of birth in that circumstance. President Bush, I think, issued a signing statement treating that provision as constitutionally unenforceable, as an intrusion on the recognition power, the asserted recognition power of the executive branch. That case goes to the Supreme Court. I guess what I want to pose to anyone who wants to answer here is, how should that question have been answered by the court? Michael?
In the first instance, I think it was simply a mistake to view the content of the passport as having anything to do with the recognition power. That has never been one of the traditional ways in which a country recognizes another. But let's put that aside and assume that it does go to that. So the Supreme Court held that the president has the recognition power, and in effect, that it didn't, although it didn't use the word, it held that it was a prerogative power of the president, that is, one that is vested in the president, that Congress cannot gainsay. So if the president recognizes a particular country, that that is it, and Congress, even when Congress is acting within the scope of its enumerated powers, that Congress has to conform to the president's recognition. I think that was a quite untoward holding. That has never, I mean, to speak of practice, that has not been the practice consistently through the country's history. Congress very frequently takes actions which have the effect of determining what country we're going to be recognizing. They do this, for example, in connection with their power to regulate trade with foreign nations. When you regulate trade with foreign nations, you necessarily are determining what nations you're trading with. If, for example, Congress passed a tariff law which recognized goods coming into this country from Jerusalem as being within the quota ceiling for Israel, I think that would be entirely within Congress's authority, even though it seems to indicate that Jerusalem is in Israel. And I don't see why putting the word Israel on a passport would be any different than that.
Is that, just to come back to the typology you gave us at the beginning, is that because you would see this power as what you're calling a residual power, so subject to defeasibility by Congress, or is it because whatever amount of that power is prerogative just isn't really interfered with by a statute along these lines?
So I do think that this is part of the residual executive power.
Okay.
There is early practice that supports this. There was a major debate during the Washington administration over whether the new revolutionary regime in France was the legitimate government. We had signed a treaty of amity, a treaty of friendship with the King of France before the revolution, and the question became, and that treaty required us to support France in a war. Well, now revolutionary France was going to war against Britain, and the question was whether Washington could declare neutrality and not go to war on the side of France. The conclusion, Hamilton most famous for this, but I think consistent as well with Jefferson's writings around the time, was that part of the executive power was to decide, at least provisionally, and that's, I mean, Hamilton made it clear that if Congress wanted to come in afterwards and disagree, that Congress had the authority, but the president provisionally could decide this question, but that he didn't have the power to do it absolutely.
Gotcha. Daphne?
So I actually agree. I think this was a question where text structure and practice all pointed away from the outcome of the majority. And so the one thing that I'll just add to what's been said in thinking about the way that judicial precedent plays into all of this is the force of the decision, as others have written, I think will really be felt in the internal legal practice of the executive branch. And so creating a hard, clear doctrinal rule that the president could disregard the statute here changes what Jack Goldsmith has called the dynamics of restraint within executive branch lawyering, and dynamics between executive branch lawyers and political principals pushing for foreign policy goals. And so I think as a matter of doctrine, it's wrong, and as a matter of norm sustaining, it's potentially dangerous.
Yeah, Jack's among those who's pointed out that the theory of executive power in the majority opinion in Zivotofsky is more aggressive than the theory of executive power in the executive branch's briefs in the case, which is interesting. Eric?
So here's why the court came out the way it did. The statute was dumb. Congress was acting irresponsibly. Okay, so the presidents have taken the lead on these sorts of issues. They've been doing it for many decades. These are incredibly subtle, complicated, difficult issues. I mean, just the whole thing about whether Israel is going to be put in the passport, has nothing to do with recognition. It's just this like subtle little thing to try to prevent another riot from taking place in the West Bank or Gaza. Okay, and the State Department and the presidents over years say, this is a kind of a compromise. It'll just keep things quiet for another 6 months, while we struggle to prevent the world from falling apart. And then Congress, as it does from time to time, says, oh, this is a great political issue. This will get me reelected at home. They're not going to be held responsible if there's another war in the Middle East. Nobody blames Congress for that. They're going to say to the president, oh, well, you blew it. You were too aggressive with Israelis or not aggressive enough or whatever, and that's your fault. And that's why the court held the way it did. And it wasn't completely devoid of sort of like legal reasoning. There's a long tradition of the court. The court doesn't always rule in favor of the president with respect to foreign relations, but there's a long tradition going back a very long time in which the court and really Congress and the other actors in government acknowledge that just as a matter of practice, you need one person to lead the country to deal with other countries, to deal with foreign countries, to conduct foreign policy. And the United States has to act in a consistent way with respect to foreign countries. And if you have a hierarchical branch of government led by a single person, that type of consistency is at least possible. If instead you have the multi-member Congress, where the members of Congress are concerned about local constituencies, and you've got all these problems of aggregation that are well known, which result in inconsistent judgments over time, you're going to have a chaotic foreign policy. This doesn't mean the president always wins, but it does mean that when you get cases like this, the Supreme Court is going to be much more deferential to the president's view. I don't think this case is going to have any real long-term consequences. The court will back off if some president says, I'm just going to get rid of this. Well, I shouldn't say that. I was about to say I'm going to get rid of this treaty that Congress negotiated. Well, they can do that also. But certainly, if it was a non-trivial statute, one that addressed tariffs or the terms of trade with other countries, I doubt very much that the court would say, oh, well, since we decided this way for this ridiculous passport issue, now the president can do whatever he wants whenever he disagrees with Congress.
So I'll come to Gene in a second, but you're having expressed your view that way, Eric. It raises the question, which was the first question that came up in Zivotofsky, whether the court really should have gotten involved here at all, because the status quo was the executive branch doing what it was doing and not complying with the statute. And so the first question in litigation was, does this whole thing just present a political question? And a lot of the arguments in favor of thinking of this as a political question are the same sort that you just described as arguments really in the merits, the sort of need for there to be one actor within the government that's going to speak on behalf of the government, of the country here, and so this just isn't a place the judiciary ought to be treading. And the original brief of the Justice Department really said, A, we think it's a political question. If it's not a political question, we win on the merits. And court, we're going to give you the same set of arguments on both points, effectively. We'd like to win on one. If we don't, just read that section again, and that's our argument on the merits. Is there any difference for you between those two?
Well, not really. The court has been backing away from the political question doctrine for a long time because they want to, have their hands in everything. I don't like that. I'd rather that they had ducked this case and maybe by using the political question doctrine, maybe in some other way.
Yeah.
But that's not really my point. I don't think those sorts of details make much difference.
But you say you don't like that, but your view is this was a dumb statute, and therefore the court was right to disregard it. And if there were a smart and important statute, well, the court will come out the other way. That puts the court as the maker of our foreign policy. This isn't your president unbound. This is your Supreme Court gets to decide our foreign policy. I don't understand that position.
As long as they're deferential to the president, I'm fine. I don't care what they can. So they do it in a million different ways. They can use the political question doctrine. They can interpret. They can accept the president's interpretation
So
of
the
a
court
vague
can do what
statute.
it wants as long as they defer to the president.
Yeah, well, that is the doctrine. That is what we teach in foreign relations law. The details differ from case to case, but the trend has been deference toward the president, but again, not complete abnegation. How the court should accomplish that in any specific case, I think, will depend on any number of factors. But I think they behaved reasonably in this case.
Gene, you can weigh on this too if you want to, or we can move to our next example.
I don't have strong opinions about Zivotofsky.
Okay.
I would just say in terms of whether there's a difference between how the
Yeah.
court resolved the question
Yeah.
and the political question doctrine, that, again, I think there's a quite dramatic difference in terms of the legal precedent that the court has set, that then the cases that will come to the court on this, again, will be very few and far between, but the cases that come, the legal questions that come to executive branch lawyers in foreign policy are every day. And so in creating the sort of precedent that the court did in Zivotofsky 2, I think there's a profound consequence to that's quite different from had the case been decided on political question grounds.
Right. If there were any inclination by executive branch lawyers to have tried to impose some sort of internal to the branch constraint, reading this opinion would sort of remove any rationale for doing.
But is there much indication, for looking at the OLC in recent years, that there is much inclination
Well,
to do that?
that's a fine question. Some of my best friends have expressed views on that.
Well, but you can see even from the position that the executive branch put forward in the court in Zivotofsky 2 that there had been more constraint created internally than what the court ultimately decided was the appropriate way to go.
Right. So figuring out whether there's constraint, within internal to the executive branch legal advice, I think is one of the important questions for today for any of these conversations. And as I think all of us in one way or another have attempted to think through those kinds of questions, I'll just say, for whatever it's worth, my own view is it's exceptionally hard to do. It's the case that an overwhelming majority of the accessible written opinions by OLC on any particular question of executive power cut in the direction of, yes, you can do that. It's also the case that we know that the most often form of no is oral advice that then leads to a conversation between the advising lawyer and whoever the client is about what they really need to do, and they try and negotiate, well, if I can't do A, can I do A prime? And where the lawyer will say yes to that, having said no orally to A. So that's a form of constraint probably, but it's going to be hard to track. The other thing, though, that one could say is that insofar as OLC and the SG's office had been prepared to describe a more cabin form of executive power, I bet that someone like Eric would say, well, that's because the president didn't need the broader form of executive power in either of those prior cases. So it's hard to know whether that's constraint or just there wasn't an occasion for it. And I myself just genuinely don't know how you sort out between those two. I don't think it's easy to come to an answer.
The lawyer's instinct is to provide the narrowest possible justification for what the president wants to do, and that's what OLC does. But as the president wants to do something more aggressive, then they they expand it a little bit each time.
Yeah.
That's how they do it.
But I think this is in part why it's in some ways obscuring when what we're trying to do is identify constraints on executive power, to be very focused on identifying the legal lines and the legal rules or the legal norms versus non-legal, because oftentimes the constraints that are created are not framed in legal terms, and strategically so. So we'll see executive branch lawyers talk about what they see as norms that are empowering to the presidency as a gloss, a legally salient gloss, and we'll see them talk about norms that are fundamentally constraining on the presidency, more in terms of policy or in terms of conventions or in terms of non-legal norms. But if we move away from this legal, non-legal label, what we see is a system of normativity that is both empowering and constraining.
Except that, ours is a very legal culture, and when lawyers say, there's no legal problem, but we have these policy norms, the policy people feel perfectly free to judge policy for themselves.
Yes, although sometimes the two may be linked, right? And so you mentioned the debt ceiling, Michael. So there were various theories about maybe the government just mint this giant coin of sufficient size to deal with the debt problem all in one fell swoop right there, and there wasn't necessarily great need for a formal legal opining on that, because as a practical, political, and other matter, it just wasn't a course that was going to be taken. And so that's some merging, I think, along the lines of what Daphne's talking about, of some combination of legal consideration together with strategic policy and political judgment, and constraint could exist in the overlapping territory among those.
Although, if I recall correctly, the General Counsel of the Department of Treasury made a statement to the press that they were not going to evade the debt ceiling, and I think that was a considerably calming statement to make.
Agree. And I guess what I'm saying is whether that was just a legal judgment or reflected an underlying sense that, practically speaking, this would not have been a course that the government could have taken, would be the way in which the picture would be complicated along the lines that Daphne is suggesting.
Yeah, and I think when we ask the question of, is the president constrained, it's not just when a question is presented, can the president act in a different way? It's also, what's the administrative and institutional infrastructure that builds up around the person of the president that makes it much harder for the presidency to act in that way in the first place, to see it as an option on the table in the first place. So if we think about the investigatory independence norm and the development of White House contacts policies that have just limited the sorts of communications between the White House and the Justice Department, or professional norms within the FBI about what the FBI sees as legitimate investigatory judgment calls, that this creates an infrastructure of constraint that's much more than just does the person of the president think that he can blow through these normative lines or not.
We've got about 5 minutes left, if I'm understanding my minders correctly. And so welcome questions from the audience. We have someone who's got cards here. So the idea is that you would write them down, and those questions written on cards will be sent down to me, and then see which ones we can pose. While that's happening, let me just invite the panelists to offer their thoughts on how they would resolve another question. So we talked some about, just before the panel, about getting into a little bit the president's appointment authority and removal authority. So one could take any number of examples in that space, but think about the recess appointment power in the Noel Canning case. So there's a case also that went to the Supreme Court, like Zivotofsky, where historical practice seems to have been a big part of how at least the Supreme Court resolved the case, not how the DC Circuit resolved the case below, which looked more just to what it took to be the original understanding of the Constitution. And in that case, where the executive branch lost, unlike Zivotofsky. Michael, was that more or less the right approach by the majority in Noel Canning, or no?
Well, I'm a little puzzled by the Supreme Court's decision to move beyond its actual holding. Its holding was that the Senate was not in recess, and therefore there could be no recess appointments, and that's because it held that these little 3-day nominal sessions were real sessions. If they're going to hold that, I think that the court should not have reached any of the broader questions in the case, and I think that the answers that it gave to some of those broader questions are dubious and completely unnecessary.
Anyone else?
Just a general comment. A recess appointment served a very different function in the 18th century when it was much harder to get from one place to another. And so it was much more difficult. So you would have these much longer gaps between sessions. And today, so I think, without going into the details about the case, I think it's worthwhile. I think this is a strong situation for looking at the historical development and seeing how Congress acquiesced to what the president did to the extent that it did. That struck me as a reasonable way of thinking about the problem.
Mm-hmm. Gene? Do you want to take a mic? Just yeah.
Sorry, I keep forgetting. It is sometimes unpredictable to see how these things play out, because I remember impassioned Washington Post editorial about how President Obama should have the constitutional power to decide for himself whether the Senate was really in session or not. And, lo and behold, a few years later, when President Trump is ranting about his beleaguered attorney general and apparently contemplating using the August recess to appoint someone more compliant, it was those pro forma sessions that, well, protected Sessions.
Okay, let's go to some of the questions we have from the audience. So maybe we could start with either Daphne or Eric on this. I think things you've said might relate most closely to this. So the question is, what role should public opinion before a presidential action, so public opinion as revealed through polling, for example, what role should it play in how we evaluate the exercise of presidential power in question? And maybe I could extend the question and say, what role do we think it does play, and what role should it play, if you would answer those, to the extent you would answer the does and should differently or the same?
Well, so one thing that we've actually seen in it as a change in the presidency over time is the idea that the authority of the president to act comes from this political mandate, from an idea of democratic accountability, and it's been a norm-based change in the presidency that's very different from the initial founding conception of the office, that has, for better and worse, and I think that there are both advantages and dramatic disadvantages to this reality, made presidents much more responsive to public opinion and seeing their authority as stemming from a political mandate. And our legal system, our structural system of constitutional government, seeing presidential authority as much more deeply tied to an idea of democratic accountability. So I think that there's significant disadvantages to where we are today. I also think, though, and I think Eric alluded to this in his opening remarks, that a presidency that is gets its authority and legitimacy in forms disconnected from democratic will probably would not have survived the changes that we've seen and the expectations of democratic governance over time.
Let me just add very briefly. I'm sorry, Michael, you'll probably want to respond to both of us. I think polls, it's not always clear whether one can trust a specific poll. But as Daphne says, the presidency ultimately depends on political support. And this is not just true in terms of getting reelected and staying in power. It has a constitutional dimension. And I think the reason why the presidency has evolved in the way it has is that presidents responding to the pressure of public opinion have asserted new powers, or Congress has given them new powers, and that over time public opinion continues to support the use of those powers. And because public opinion evolves and the public itself changes and technology evolves and so on and so forth, this is why the powers of the presidency have changed so much over the last several hundred years.
Michael, you got last one.
So If the question is what's the role of public opinion reflected in polling on how to evaluate the legitimacy of presidential action, I say it has no role whatsoever with respect to the legitimacy of presidential action. The law, we don't care what the polls say, and we shouldn't care.
What you mean by legitimacy is legality.
Legality,
Yes. Okay.
that's right. Now, of course, polls have a lot of political importance. Of course they do. But I would want to urge that I think that, and this is not a legal point, this is a point about statesmanship, that we don't elect presidents to do what the polls say. We elect presidents to do the right thing and to lead the people, and then we decide whether we think that we've been led in the right direction. But a president who does nothing but follow what the polls say, I think would be a miserable president.
So, unsurprisingly, I think we've raised far more questions than we've answered, but hopefully this has been a useful initial raising, and hopefully we haven't run too far over our time. So am I right that we're going to take a shortened break of just 5 minutes? And so that's enough time for coffee and then coming straight back, I think. Thanks very much.